Hello and welcome to TaxPundit.org. TaxPundit is India's most popular and trusted database of income tax case laws. In today's video, we will be analyzing a landmark case study that provides critical insights for tax professionals. Let's dive right into the details. The case under discussion is Deputy Commissioner of Income Tax versus Indian Crable NetCo Ltd. The assessee, Indian Crable NetCo Ltd, filed its return for assessment year 2016-17 declaring total income of Rs 3,16,80,608. The AO observed that the assessee claimed depreciation of Rs 7,89,99,274 on goodwill arising from the amalgamation of Messrs Poultry Trading Private Limited, effective the 31st of March 2014. Approved by the Kolkata High Court on 8 May 2014 under Sections 391 to 394 of the Companies Act, 1956. The AO disallowed the depreciation, relying on the fifth proviso to Section 32(1) and Explanation 3 to Section 43(1). The AO argued that the goodwill was a mere accounting entry to claim bogus depreciation, as the amalgamating company had not claimed depreciation on goodwill before amalgamation. The AO also cited DCIT versus Toyo Engineering India Limited and United Breweries Limited. On appeal, the CIT appeal allowed the assessee's claim, distinguishing the cited cases and following the Supreme Court rulings in CIT versus SMIFS Securities Limited 2012-348 ITR 302 SC and Zydus Wellness Limited. The revenue appealed to the ITAT while the assessee filed a cross-objection challenging a disallowance of Rs 4,20,350 under Section 14A read with Rule 8D. The tribunal upheld the CIT appeals order, emphasizing that the goodwill was a purchased intangible asset, not self-generated. The amalgamation was court-approved, and the assessee paid consideration in shares. The excess payment over net assets constituted purchased goodwill. The fifth proviso to Section 32(1) applies only to self-generated goodwill. The tribunal noted that Toyo Engineering was set aside by the Bombay High Court and later decided in favor of the assessee. United Breweries was distinguished because that merger was with a wholly owned subsidiary, leading to self-generated goodwill. Here, there was no holding subsidiary relationship, so the goodwill was purchased. The AO argued that the goodwill was a bogus entry, citing an ex parte assessment under Section 144 against Poultry Trading, adding Rs 15,020 crores for a bogus unsecured loan. However, the CIT appeal noted that this addition was deleted by the CIT appeal on 29 March 2019, and the ITAT upheld that deletion on 1 September 2022. The tribunal held that the fifth proviso does not bar depreciation on goodwill arising from amalgamation. It relied on Milan Laboratories Limited versus DCIT, which held that the sixth proviso, earlier fifth, has no applicability to goodwill generated on amalgamation. Explanation 3 to Section 43(1) also does not apply as the goodwill was not a mere book entry. On the cross-objection, the tribunal ruled that no disallowance under Section 14A read with Rule 8D is warranted when the assessee has not earned any exempt income during the year. The purpose of Section 14A is to disallow expenditure incurred in relation to exempt income. If no such income exists, the provision cannot be invoked. The assessee raised an additional ground challenging the disturbance of the opening W.D.V of the goodwill asset. The tribunal admitted this ground as a pure legal issue. It held that the department had not disturbed the W.D.V in preceding years, so the opening W.D.V could not be re-agitated in the current assessment year, aligning with consistency. Question: what was the main issue in this case? Answer: The main issue was whether depreciation on goodwill arising from a court-approved amalgamation is allowable under Section 32(1) of the Income Tax Act, 1961. Question: why did the AO disallow the depreciation? Answer: the AO disallowed the depreciation relying on the fifth proviso to Section 32(1) and Explanation 3 to Section 43(1), arguing that the goodwill was a mere accounting entry and not a genuine asset. Question: how did the tribunal distinguish the United Breweries Limited case? Answer: the tribunal noted that in United Breweries Limited, the merger was with a wholly owned subsidiary, resulting in self-generated goodwill. In the present case, there was no holding subsidiary relationship, so the goodwill was purchased. Question: what is the significance of the SMIFS Securities Limited case? Answer: the Supreme Court in SMIFS Securities Limited held that goodwill arising on amalgamation is an intangible asset eligible for depreciation under Section 32(1). The tribunal followed this binding precedent. Question: can Section 14A disallowance be made if no exempt income is earned? Answer: no. The tribunal held that no disallowance under Section 14A is permissible when the assessee has not earned any exempt income during the year. Question: what was the outcome of the additional ground regarding opening W.D.V? Answer: the tribunal allowed the additional ground, holding that the opening W.D.V of the goodwill asset could not be disturbed in the current assessment year since it was not challenged in preceding years. Thanks for watching this video. You can download the full legal analysis, the official case law, and a concise case digest PDF directly from our website, taxpundit.org. If you have any questions, feel free to write to us at taxpundit@taxpundit.org or message us on WhatsApp at 9326306668. Don't forget to subscribe to our channel for more authoritative legal updates.